Hi guys, it's Kathy. I hope you're doing well. Today we're going back to Judge Wolfe for a little bit for an excellent case. And then we'll see some other judges. Here we go.
Rise.
This was November.
We'll back in session. Have a seat.
All right, I'm going to take up the matter of Butler versus Butler. All right, Mr. Butler has filed a motion to alter or amend the judgment in this case. And Mr. Butler, this is your motion, so I'll be glad to hear you.
Yes, sir.
Come to the podium.
Yes, sir. It's hard to remember. I'm currently incarcerated, right now and trying to remember everything since I've had no time to really prepare since this. I've also filed a motion for mistrial, and is that part of this too? Or-
I have a motion to alter or amend, and I then have a,
Sorry.
so I'm giving you an opportunity to address all of the issues that you have raised in your motion to alter or amend. Do you not have a copy of it?
I'm not with me, no, sir, because I'm incarcerated right now, due to being targeted.
Let me tell you what you said in your motion. Says that you're filing this motion pro se pursuant to rules of civil procedure 59.04 to alter or amend the final judgment in the following basis. You allege the final hearing was held in the matter on July 14th, 2025 and July 15th, 2025. The court's judgment is based on erroneous findings of fact and a fundamental failure of due process, which constitutes a manifest injustice. And do you want to address that issue and what it is that you're saying occurred that
Yeah, the illegal ex parte meeting that happened during the trial that happened, and then also, I think it was $800 a month I was supposed to pay in child support, and that was based on her income. And I do remember you specifically saying that the child support should not be based on her income due to me. Like I was laid off from my job, and I wasn't looking for a job because I am, and I've never made as much money as she has.
Well, I want to address that second statement you made. Paragraph 3 of your motion states the court engaged in improper ex parte communication. During respondent's cross-examination of the petitioner on July 14, 2025, the presiding judge, the petitioner, and the petitioner's attorney exited the courtroom and held a private meeting in the judge's chambers. The respondent was excluded from this meeting, which violated his fundamental right to due process in the Tennessee Code of Judicial Conduct, Rule 2.9.
Yes, sir, that did happen.
You're alleging that I had a communication with the attorney for the petitioner and the petitioner and about your case?
I'm not exactly sure what happened. I just know that.
Well, you've made an allegation, which I consider to be a very serious allegation.
Sure.
And when I'm talking, just wait for me to finish. So I want to know what proof you have that such a meeting took place, because I can tell you it did not. But I want to hear what evidence you have that you would have placed in such a motion.
So the only evidence I have is that when we were here, and I was actually questioning Mrs. Butler, that all of a sudden Miss Margaret got up and then she got up, and I noticed that you three went through that door, and then I was just left standing here. I didn't know what to do, so I went back and I sat where that man in the blue shirt is right there. I went back and sat right there for about 10 minutes. Miss Butler exited that door. And then about 5 minutes after Miss Butler came out, Miss Margaret came out, and then you came out. I don't know what you guys said. I just know that.
So
that
you
happened.
have no evidence that any such so-called meeting occurred between me and Miss Brady and the petitioner in this case. You're just assuming that such a meeting occurred because we left the courtroom at the same time. Is that
I
correct?
just don't know what else would have happened. I did file for a mistrial first. And I don't know why that didn't come through. But I do know that I wasn't getting dates while I was filing stuff. So I tried to, I did the mistrial first to make things, I don't know if it would make it right better or, I'm just trying to do the best I can, Your Honor. I lost my son. I was doing everything right. Like the courts asked me to take a drug test. I passed it. I didn't get my son. I lost my son on false allegations of drug use. And did everything the courts asked me to do. I still didn't get my son back. I lost everything, Your Honor. I lost literally everything. And I've had the Cheatham County Police, they've targeted me, and I've got evidence of that. And it's just, look at me.
Paragraph 4, you allege that the petitioner provided false testimony under oath regarding allegations of domestic violence, which the court relied upon in its ruling. You vehemently deny the allegation that you jammed your thumbs into the petitioner's eyes or punched her. Basically, you're saying that I relied upon false testimony, but I heard both sides of that testimony. Well, I heard her testimony, and I think you were pending criminal charges at the time, correct?
Yes, sir.
Okay. The paragraph 5, the court's judgment relies on a pattern of false allegations. Prior to the final hearing, the petitioner filed an ex parte motion to suspend your parenting time based on claims of drug use and unsafe home. Those claims were investigated by the Department of Children's Services and were proven false. Furthermore, you passed an court-acknowledged 10-panel hair follicle drug test. Anything you want to add to that? I'm considering your motion, so I'm giving you an opportunity to
Yes, sir.
provide me with any kind of proof regarding your allegations.
There was also, there's the allegations that I was homeless, and then they came and inspected my house as well. And did a home visit, and she saw I lived in a beautiful home. I was very stable, and after that, Judge Turnbow, I didn't get to get back in front of him because he went. They go. I guess y'all guys alternate. So I filed another motion, and I was running late to court that day due to my car issue, and I've since filed a motion for that. And but I called as quickly as I could, and the lady said that your case had already been heard, and they're not going to do anything. And I was just devastated. I was just like, because I thought that would be the day I get my son back.
All right. Paragraph 6, the allegation of harassment at the ninja class is further evidence of this pattern. The petitioner obtained an order of protection based on claims of harassment and threats. The incident did not occur. Class was held in a small room filled with numerous parents and children. No independent witnesses came forward to support the petitioner's story because it did not happen. Paragraph 7, the petitioner's attorney made false representations to the court. Respondent inadvertently sent a draft email with no threats to attorney Margaret Brady. Attorney Brady then falsely told individuals in the courtroom that the email contained threats and a deliberate attempt to poison the proceeding. So you have filed a motion making these allegations, and today is your day to show to the court the basis for any of those allegations.
Sure. So for the ninja class, it was worded in such a way that I so happenly showed up there, and I feel like the way that things were worded to obtain this no contact order, it was specifically for that and for that only. And just before that incident, or there really was no incident, I was trying to break contact off of Miss Butler because of just how angry she was, and I just wanted to support my son. I've been there since day one supporting my son. And for whatever reason, these people just come out of nowhere and just don't want me in his life. And that's exactly what has happened. And then there was no need for a no contact order. There was no need for that at all. And it was there strategically to violate me. 100%. And it was malicious, if you ask me. That's how I feel. I don't have anything with me right now, but, and then also my probation was violated at the wrong place at the wrong time, and I'm fighting those charges and more than likely will win. And, Miss Brady, before the proceeding of the violation, was telling the courtroom that I have a draft email, and for whatever reason, it was addressed to her, and it was nothing of the sort of threatening. And Miss Brady was talking about it in the courtroom the day before my violation was set to be heard. And my attorney said, "Where's this threatening email?" And I gave it to him. I said, "Here." And there was nothing in there threatening. So for whatever reason, I felt like she was trying to poison the well before it even got started. Because, her sister-in-law does work down there.
All right. Have a seat at the table. Ms. Brady, do you want to respond to the motion to alter or amend the judgment?
Your Honor, we would just say that,
You'll come to the podium so
Sure.
let's pick up.
sorry. Obviously, we would say there's no ex parte communication with the court, but all the other things that he mentioned in his motion are based on witness testimony, and the court had that opportunity to hear that then and deemed Ms. Butler's version of events to be credible and made a ruling based on that. And we would say that there's no grounds for to alter or amend this judgment put forth by Mr. Butler today, and we'd ask that be dismissed and this be considered a final order.
Number one, the court specifically will address the allegation that the court engaged in an improper ex parte communication. Mr. Butler has affirmed on the record that he has no evidence of such a meeting occurring, other than the fact that circumstantially Ms. Butler and her attorney, Ms. Brady, exited the courtroom, and that I exited the courtroom at the same time. That alleged meeting did not occur. There was no ex parte communication between me and Ms. Brady and Ms. Butler. And I specifically find that allegation was made without any evidence and nothing more than circumstantial belief by Mr. Butler that somehow something was being done inappropriately. So I find that basis is a false allegation regarding the behavior of this court and that of Mrs. Brady as the attorney for Ms. Butler. In addition to that, all of the other, as Ms. Brady has pointed out, all of the other allegations that he makes are all basically complaints regarding the court's findings at an evidentiary hearing. And the court finds that the testimony that was offered at that hearing was the basis for the court's order that was entered, the final hearing order. And that final hearing order was filed September the 2nd, 2025, which was after his motion to alter or amend. And that hearing order was based upon the facts as were presented in this court at the final hearing, where Mr. Butler was present and given an opportunity to participate. And that as a result of that, no evidence has been brought forward to satisfy the court that there's any basis for an alteration or amendment to the court's prior order. Therefore, his motion to alter or amend the judgment filed August 25th of 2025 is overruled. Then there are some additional motions that have been filed, and I would like to address those motions, and Ms. Brady, unless you need additional time to consider them. He has filed on October the 1st a motion to reconsider and amend the final order as to child support.
Which might not be the top of your list. I filed a motion to dismiss all of the remaining motion and for sanction. And so if we have argument on my motion to dismiss, it might resolve those motions Might be a way to handle it. Probably won't be able to see.
Well, we'll consider your motion to dismiss, considering, and consider that before we take up any of these other motions, because if your motion is valid, then it will not be necessary to consider those additional motions.
Your Honor, so the other motions were not, as you know, set on the docket today, but I wanted to bring them all up before the court today so we could just deal with this all together. So as you can see, I filed a motion to dismiss. He has additionally the motion to reconsider and amend as to child support, an emergency motion to reinstate parenting time, and for immediate hearing, a motion for mistrial. There was a motion for personal items that's already been dismissed by Judge Turnbow because for failure to prosecute. So on these remaining motions, Your Honor, I would say that these are going to fall kind of in the same lump as the motion to alter or amend. They're all based upon problems that Mr. Butler has with testimony that the court considered that he had an opportunity to cross-examine and participate in that hearing. And we would ask that all of those be dismissed. And furthermore, Your Honor, we've also asked for sanctions pursuant to Rule 11.02. And specifically, Ms. Butler is asking that she be reimbursed for her attorney's fees to defend this motion today. As we know, there's been a history of harassment and stalking and domestic assault. And now that Mr. Butler is unable to do that out on the street, he's using this court to continue this harassment because he's dissatisfied with the court's ruling. And he has had no basis to for these motions. And so we would ask that he be responsible for attorney's fees today. Additionally, though this was very late filed, and I'll acknowledge that, I filed a motion to relocate, and also we're having a problem selling the house. I understand if Mr. Butler doesn't want to deal with that today, he has that right. But you had asked that if we can't get the house sold at list price, that we need to come back and talk to you about that. And they've had one showing the whole time that it's been on the market with no movement. And we're asking that if the court will hear that today, that we be allowed to accept the reasonable recommendation of Amanda Bell, who is the realtor, and just try to get this house sold. But I understand if that needs to be reset.
When you say I had asked you to come back and talk to me, you were talking about having come back to court on that issue.
Yes, Your Honor. So in our final hearing or final decree, you had said if she's not able to sell it at list price, that we needed to get permission from the court to reduce that price so that there was a basis for it. And if you need to hear from Ms. Butler, we can do that to describe
you
that.
just filed it yesterday, so I'm not going to require Mr. Butler to have a hearing on that particular issue because of the fact that he's entitled to 5 days notice prior to that. We can set it later in this month for a hearing, but it would not have to be, it would not be fair to him to have a hearing today with a motion filed yesterday.
I understand.
Mr. Butler, did you raise your hand? Do you have something you wish to say?
Yes, sir. The house is listed way too high. It's listed at like almost
Come up
400,000.
to the podium.
She has the house listed way too high. It's at 400,000. It's not worth that much. I understand that the market value has fluctuated these last few years, but it was nowhere close to that. And then also with the motion for emergency custody was because I satisfied everything the court needed me to do. But right now I'm incarcerated right now with no probable cause. So, that's why I can't keep up with everything. And a lot of this is not based on, I don't know. I've lost everything. I lost my son. I've lost literally everything for nothing. And they just want to take more and more and more and more. I can't even afford a lawyer, but I got to pay for her lawyer fee. And then they got the house marked up way too hot. And then, Your Honor, I just really hope you'll take into consideration that, a lot of this was done, and I have been targeted by the Cheatham County Sheriff's Office. They violated my probation the first time based on words. And then, I've got proof of it. I've got proof of it. And a lot of it came from her. And I just really hope you'll take that into consideration, Your Honor. I mean, I've been a good parent. I'm a supportive parent. I've worked our entire marriage. I've worked until I lost my job. And then on top of that, I didn't just sit there. I went out and I made money. It wasn't, a bum. I did what I could for my son. I went from being that dad every day with my son to nothing. And they just took everything out of my life. I'm in jail right now for nothing because they targeted me so she could win 100%.
All right, you have also, and Ms. Brady, I'm going to go ahead and consider these other motions on the record because it's my understanding he's filed an appeal. Is that correct? He's filed a notice of appeal to the Court of Civil Appeals, and therefore I think that all of these motions need to be addressed that he has raised regarding the final hearing. So the next motion that I'm going to take up is an emergency motion to reinstate parenting time for immediate hearing. Mr. Butler, you have filed a motion to reinstate your parenting time.
Yes, sir. I did. That was before I was on private property, and the Cheatham County Sheriff's Office came up and arrested me for being on private property, and now I'm here. And so if I were to win this, I guess I couldn't get it anyway because I'm incarcerated. But so I don't know if maybe when I get out, if you were to give it to me. But Miss Butler's whole goal was to move back to East Tennessee, where she was from. That's why this, the no contact order for no reason came into play. And that's why a lot of this is like the whole targeting thing is like so aggressive, is so that way she can move back to East Tennessee. 5 hours away. I mean, no, not that I'm a bad dad, not that, I'm out partying, I'm out doing drugs, nothing. It's just bull. And they've got me hemmed up. I mean, it's hard when you're a small guy. You got no lawyer. I did have a lawyer. She withdrew from my case because of Margaret Brady. I've got her on tape saying that. She doesn't want to go against Margaret Brady. She's took all my money, so I had no money left, so I had to defend myself, and I still lost fucking everything. I mean, I've lost everything, Your Honor. I'm sorry. I'm not. It's just. I mean, I'm a good dad that's fighting to be with his son, and I just keep getting shot in the foot. It's pretty bad. It's pretty.
All right. Your motion to reinstate parenting time for immediate hearing is going to be denied simply because of the fact that you're incarcerated. I'm not going to reinstate parenting time because you are incarcerated, but the final order in this case provided that upon your release from jail that you would have the right to exercise supervised visitation every other Saturday and Sunday from 9 a.m. to 5 p.m. each day with no overnights. That would be supervised by a third party agreed upon by the parties. That you would be permitted to petition the court for review of your parenting time after your criminal charges were resolved without the necessity of showing a material change of circumstances. I don't know how I could be any more fair with you in the situation that you're in. All of your argument has to do with how unfair you think it is that you're incarcerated. That's not an issue before this court. The fact of the matter is you are incarcerated.
You're right.
And because of that fact, you're not going to have visitation with your minor child or children until you are resolved of that. And this final order that I put down provides a method by which you can have visitation, and you can even have it reviewed after all your criminal matters are resolved to try to reinstate some sort of a normal visitation. So your motion to reinstate and your visitation immediately is denied based upon the fact that there is provision in the order for that to take place. The next motion that you have is a motion for a mistrial, and I will just simply, I don't even need to hear any argument. Your motion for a mistrial is based upon paragraph 1, ex parte communication, July 14th, 2025, during the final hearing in this matter, the presiding judge, Judge Wolfe, plaintiff Aaron Butler, and plaintiff's counsel Margaret Brady left the courtroom together and entered into the judge's chambers for approximately 20 minutes. Defendant Robert Butler was not invited nor informed of the content of the discussions and was not given an opportunity to respond. The ex parte communication deprived the defendant of due process. I've already addressed that issue with you. You have affirmed on the record that you have no no evidence of any such meeting occurring, that it was all circumstantial because I left through this door to my right, they left through the door to my left, and as a result, during a recess of this court, that you assumed that there was some sort of ex parte communication. I affirm on the record that no such communication took place and no such meeting took place, and that allegation was based upon a false statement by you. Therefore, your motion for a mistrial is denied. All of the rest of this, of your motion for a mistrial, which is not appropriate after the final, you don't file a mistrial motion after the case is concluded. And for that reason, in addition to the fact that I've considered all of the other bases, and there is no basis for a mistrial to be granted after the entry of the final order in this case. The last motion is a motion to reconsider and amend the final order as to child support. And at that point in time, I found that the mother's income was set at $6,000 a month in the final hearing, that your income was imputed even though you were in jail pursuant to the rules of the child support guidelines, simply because of the fact that if you were unemployed, it was due to your own fault. As a result of that, you could have the imputed income that the child support guidelines provide. I applied that to the calculation of child support, and therefore you're not entitled to an amendment as to the calculation of child support. That concludes all of the motions that are set, other than the motion to relocate, which was filed yesterday. I will not consider that until he's been given appropriate notice, an opportunity, and that would be later in the month that we have a chancery day we can set it.
Your Honor, I know that we're not taking up the motion for reducing the price of the home either, but since Mr. Butler seems to be on the same page as that, you think that we could consider that so that we can get that house sold and they can get some funds?
If he's willing to do it, we can. I mean, if he's willing to waive the 5 days notice and have it heard, yes. Mr. Butler, the rules of civil procedure provide that you're entitled to 5 days notice prior to the hearing on a motion that's been filed. They filed their motion to reduce the value of the property and to accept an offer less than the listing price yesterday. So therefore, you have the right to object to that, and I'll have it set later in the month, or you can agree to hear it today, and then we'll put on the proof, let them put on the proof about why they need to accept this offer. Do you understand all that?
I understand it all. I guess it just depends on how much they want to reduce the price. If she wants to work out a deal or something, I might be willing to talk about it for a minute.
Go ahead, have a seat over here, Mr. Butler, and I'm gonna let Ms. Brady talk with you, and we'll come back to you. All right.
I think that we probably should just reset both of those motions so we can get a clean order from the court, because I'm not sure the agreement that we might be able to reach is going to be workable.
Right. What day in the 24th of November?
All right, thank you, Your Honor.
Butler, those remaining motions will be heard by this court on November 24th. Thank you.
All rise.
Okay. Now we're going to go to Washington. Okay. And this is an interesting one that I even have a shorter video coming out tomorrow of it. So if you watch it here, you don't have to watch that tomorrow over in court disorder. But it's very interesting.
Okay. All right, thank you.
Thank you, Mr. Copeland.
Hello,
Good morning in the Nisqually Jail. What is your name, please?
my name is Deontay Parker.
I'm sorry, sir. What was your last name?
Parker.
I probably would have
Oh,
done
thank
what the
you.
judge does.
This is City of Lakewood versus Deontay Maurice Parker, 25L047334R. This matter is before the court for a competency hearing in Mr. Parker's matter. Previously, the court had granted a request from the defense to order a 1077 evaluation for Mr. Parker. That evaluation was completed and filed with the court just recently. This matter was before the court 2 days ago on January 5th. At that time, the court discussed with the attorneys for both parties the content of that competency evaluation, opining that Mr. Parker is not competent in this matter. At that time, the prosecution placed the defense and the court on notice of its intent to argue that the charge of criminal trespass in the first degree as charged in the criminal complaint in this case should qualify as a serious offense under RCW 1077, and that the prosecution would be seeking an order for competency restoration. Mr. Graham?
Yes, Your Honor. Your Honor, the city is seeking for the court to find this matter to be a serious offense, not as a per se criminal matter, but rather based on the factors that the court is to consider for that purpose. Looking to RCW 1077-650, the procedure for this, the first step is to decide whether or not there is a compelling state interest in the restoration.
Get ready. Here we go.
And according to that statute, the court should consider prior criminal history. And so looking first to that, Your Honor, Mr. Parker currently has had 94 charges of criminal trespass within his
94 criminal trespass within the last, 7 years?
criminal history, 2 counts of resisting arrest, 1 count of obstructing, 5 counts of theft, 1 count of controlled substance, 1 of drug paraphernalia, 4 counts of violating an exclusion order out of the city of Olympia, 3 counts of assault in the 4th degree, and 1 count of malicious mischief in the
3 counts of assault in the 4th degree. Just remember that, because I thought that was a little bit important. And you'll see.
3rd degree. A number of these charges, Your Honor, throughout Mr. Parker's history have been dismissed for purposes of competency. In fact, the majority of his history has been dismissed for purposes of competency. And it isn't just the city of Lakewood that Mr. Parker frequents. He's also frequented the Thurston County area, specifically Olympia, more than others, as well as Tacoma municipal area, SeaTac Muni, but also Lakewood quite a bit. Your Honor, while he has an extensive history, and to be fair, all of this history only dates back. The majority of this history starts in 2019. So we're dealing with the last 6 to 7 years to have well over 100 different charges within the South Sound area. The next matter is his history and treatment, Your Honor. He has been found both competent and not competent at times. His restoration has been recommended a number of times within his history, most recently by the most recent evaluation. He has been subject to the Involuntary Treatment Act quite a few times. So he does have a history with treatment. Now, whether or not he has a history of restoration, I don't believe he does. I don't believe he has been subject to restoration to date, based on what the charges look like from his history. But he does look like he would be a candidate for restoration, should such be ordered. As to a history of violence, while I understand that truly crimes of violence include assault in the second degree and greater, and do not include assault in the fourth degree as a definition coming out of, say, the Sentencing Reform Act. I do believe assault in the fourth degree is a violent act, and he does have 3 prior matters involving assault in the fourth degree within his history. As to the quality and severity of the pending charge, Your Honor, I think it's easy to say that it is not that severe, and admittedly it is not. But looking at the totality gives a different story, I believe. As to the event, this is obviously not akin to a felony matter, or even a DUI, but just the voluminous nature of Mr. Parker's history, I think should have some sway in that factor. Any history that suggests that treatment is likely to be successful, Your Honor, again, I believe that some of the prior evaluations did opine that restoration would be recommended. Most recently, they do think that it may be successful. And then finally, any other factors found within 1077-665. So looking to that, Your Honor, under subsection 3B, are the factors that I believe are referenced by that statute, which include whether or not he's inflicted bodily or emotional harm on another person. I don't believe that is true of this particular charge. The extent and impact of the offense on the basic human need for security of citizens within the jurisdiction. I think that can be viewed in a couple of ways. I think that looking at his history, telling him to stay away just doesn't seem to work. So having people feel secure in the fact of asking people to leave, being told to leave by law enforcement, and yet he still does not or is incapable of doing so. I think there is something to be said about that security that the citizens of Lakewood and the South Sound would feel. The number and nature of related charges pending against the defendant. He has a history of, as I said, 94 trespass cases within his history. So he does have a number of related charges within his history. And the length of the potential confinement, if he is convicted, this would be this is a gross misdemeanor, so a maximum of 1 year in jail, and the number of potential and actual victims impacted by his alleged acts. It seems to be varied and quite extensive if we're looking at his history. And so, Your Honor, I do think that there is a compelling state interest in seeing Mr. Parker restored so that he can become law-abiding, so that we stop seeing Mr. Parker with such frequency, both in Lakewood and in the other jurisdictions that he has come into contact with, most recently Olympia. Your Honor, I do think there is such a compelling state interest in this case. And so I would ask the court to find that.
Mr. Graham, I think part of the reason that we set the matter for today, if I remember correctly, was the pending charge in the city of Olympia. And Olympia Municipal Court was the court that ordered the competency evaluation. We kind of piggybacked onto that order. as well, and I think they received the very same evaluation. My understanding is that Mr. Parker was supposed to be scheduled to appear there yesterday. Do you know what the outcome of that hearing was?
I don't have information as to what the outcome of that hearing is, Your Honor, but what I do find of note is that it doesn't appear that that it's been closed. I have not verified if we are the sole holding authority at this point with Nisqually. That is the only other thing I could think of that might give us some indicator as to whether or not that matter has been dismissed by Olympia.
All right,
And I'll check that, Your Honor.
thank you. Ms. Grisco, on behalf of Mr. Parker, what is the defense's position concerning the prosecution's motion that the court find that the offense charged in this case, one count of criminal trespass in the first degree, does qualify as a serious offense when the court takes into consideration the factors listed at RCW 1077-665 sub 3B, and that the prosecution has established a compelling interest in seeking a court order for restoration of competency in this matter?
Your Honor, we understand the city's concerns. There have been several cases with Mr. Parker. However, Mr. Parker has been found incompetent by SeaTac Municipal Court's order for competency December 1st, 2025 in our court on the 1st of January this year. While these charges and cases are frustrating, the situations that have been in front of the court and whether they are concerning is not the question. The standard of review must be under strict scrutiny. Under the strict scrutiny lens, ordering restoration denies Mr. Parker's right to liberty. This would be involuntary treatment. And the question is whether the court has authority under RCW 1077 to order restoration for this charge. And under the statute reviewing strict scrutiny, and I don't the city does not meet that burden. The city is carrying the burden to prove restoration is necessary in this case and statutorily permissible, and they cannot. 1077 RCW 1077 draws a bright line where restoration is authorized for serious offenses. The charge in this case does not meet the statutory definition of a serious offense that requires mandatory restoration. Once there is a finding of incompetency on a non-serious charge, the statute requires the case to be dismissed, and the statute does not describe discretion to order restoration on this charge. The court must consider the charges in the allegation and if Mr. Parker actually inflicted bodily harm or emotional harm on another, the impact of the offense on the basic human need for security of the citizens within its jurisdiction, the nature and number of offenses that are pending, and the length of potential confinement if Mr. Parker is convicted, and the number of potential and actual victims or persons Mr. Parker's alleged behavior impacts. In this case, the alleged victim is Safeway, a commercial retail entity. Based on the allegation before the court, Mr. Parker does not meet the criteria that would elevate this case to a serious offense under the factors the court must consider under 1077-665 Section 3B. The first prong, the allegation does not assert that Mr. Parker has inflicted bodily harm or emotional harm on another individual. Safeway is a corporate entity, cannot experience physical injury or emotional distress in the manner contemplated by the statute, and there's no allegation that any employee, customer, or individual suffered harm as a result from Mr. Parker's allegation. This is a criminal trespass charge. Second, the impact of the offense on the basic need for security within the court's jurisdiction is minimal. There's no allegation of violence, threats, or behavior. The allegation is that Mr. Parker was eating food. This would not undermine public safety or create fear within the community. If you look at the last page of Mr. Parker's evaluation, the evaluator writes that Mr. Parker does not present an imminent risk to self or others, and therefore the offense would not implicate broader concerns regarding community safety or public well-being. Third, the nature and number of offenses pending against Mr. Parker amount to 2. The court can see there are cases in his history, but that should not be included in the calculus. These cases were not properly adjudicated and were dismissed based on a finding of incompetency. Additionally, many of the Lakewood cases did not establish probable cause, and as such, the cases should not be held against him to order involuntary restoration. Fourth, the potential length of confinement Mr. Parker faces is longer than the amount he would normally face if he was found competent. He has been in custody currently for 19 days, and given the non-violent nature of the offense, even if he were to be convicted, there's no reason to believe he would be sentenced to a greater jail term. If the court were to order restoration, he would be in custody for another 29 days, leaving him in custody for 48 days minimum. This is not in the interest of justice to order restoration just for the sake of prosecution. Finally, there is only one alleged victim, Safeway, and no indication that Mr. Parker's alleged behavior impacted a broader group of individuals. There are no actual or potential victims identified beyond Safeway in this allegation, and no evidence of widespread or ongoing harm from this matter at trial today. Together, the factors the court must consider to find a serious offense is unmet. As for potential restoration, there is a possibility of success for a serious offense. However, that does not expand the statute's authority to order mandatory restoration. Restoration is only mandatory for certain offenses under 1077-6651, and this charge does not fall under those listed. The evaluation states that if it is not a serious offense, then he is not eligible for competency restoration. It is the nature of the charge, not the number of repeated low-level offenses that justify restoration. The city is asking the court to use restoration as a way to manage the behavior. And while the city's position may feel practical, the statute is not intended to control and manage behavior. It is narrow and has careful, limited exceptions that permits involuntary treatment, which are serious offenses, and this charge is not listed under such offenses. Frustration with behavior cannot substitute statutory authority. The legislator has written what is encompassed in ordering restoration, and for non-serious offenses, such as this case, the answer is dismissal. And for these reasons, Your Honor, defense asks the court to follow the statute and deny the prosecutor's motion to order restoration and dismiss this case. Thank you.
Thank you, Ms. Grisco. Mr. Graham, you are the moving party. The prosecution has the burden based on the procedural posture that we are presently in. So I'm going to give you the last word. I know you wanted to look at the Olympia case as well. Anything further from the prosecution in this matter?
Yes, Your Honor. I did look. It does appear that Olympia has dismissed. Looking at the Nisqually jail calendar, it shows that those two charges are dismissed. So the only matter he's being held on is ours, with the $100 bail at this time. Your Honor, I understand defense's perspective. However, we are in this situation of Mr. Parker not respecting boundaries and not respecting the safety of the community and continuing to enter into locations that he has been told to stay away from repeatedly. The number of charges just out of the city of Lakewood alone leave the city with a lot of concern. Certainly, if he was restored, he could be held accountable for his prior actions, but until he is restored, we're at a point of being able to do nothing, and he is effectively a scofflaw that can ignore the law, so long as it isn't a felony for all intents and purposes. And I don't believe that was the intent of the legislature, and I don't believe that's the intent in this particular matter. I've already given the court all of the information as to history and repetition. And so, I would just leave it with that. Thank you, Your Honor.
You know, Mr. Graham, this is a very difficult question for the court. And I think Ms. Grisco has made some very strong arguments on behalf of Mr. Parker for dismissal. But I think the prosecution has made some very compelling arguments. And frankly, Mr. Parker's criminal history, not only cases involving conviction, but cases involving dismissal on the basis of lack of competency, makes the prosecution's argument a very compelling argument as well, which is makes it a tough situation for the court. Playing devil's advocate for a moment, Mr. Graham, let's say that I grant the prosecution's motion and that I find that under the criteria listed in the statute that this does qualify, although not a per se serious offense, but under the factors that are listed in the statute, it qualifies as a serious offense. And I do then have authority to order restoration of competency. And I would also have to find that the government has a compelling interest, which I think the government probably does. I mean, what I hear Mr. Graham saying is, look, the compelling interest of the government here is to ensure the community's safety and that Mr. Parker is put in a position where he is as possible as can be, that he will have law-abiding behavior for his own interests as well as that of the community. I think that safeguarding the community, I do think, is a compelling interest, governmental interest. But let's say that I grant the relief that you're seeking. And let's say that Mr. Parker goes to Western State for a period of 30 days and competency restoration is successful. And that's a question mark. We don't even know if it will be. But let's assume, for argument's sake, that competency could be restored. At that point in time, Mr. Parker will have been in custody, held under this cause number for a period of time well in excess of what the average criminal defendant charged with criminal trespassing in the first degree in this court ordinarily is expected to serve. I mean, do you see the concern the court has with this? I mean, you
Yes,
understand
Your
what?
Honor, and I would answer back with that. The court doesn't typically see somebody with Mr. Parker's criminal history. I agree that our average criminal trespass tend to see small sanctions as far as jail time or other alternatives for trespass behavior. But we don't have somebody who comes up on practically 100 criminal trespass allegations within their history. If he hadn't been, if so many of these charges had not been dismissed for purposes of competency, I could honestly say that the city would be seeking maximum penalties for somebody with his history on a regular basis. Acknowledging the mental health problems are obviously a mitigating factor that the court would consider when whether or not on how to what sort of sentence to subject him to, but to say, you know, what his average penalty would be, I don't know that that was the consideration that's necessarily the factor for the court to consider. I think the issue would be if it would be beyond what he could be sentenced to in the first place. If this was criminal trespass in the second degree and the combination of restoration and pending waiting time would put him well beyond the 90 days, I think that is the factor that is meant to be considered, not necessarily that, well, on average, we tend to see people in there about 20 days or less, or whatever the average actually is, because I don't speak with exact knowledge. I've never done that calculation. But I think that that's different, Your Honor. And I also think it's different when we look at somebody with such extensive history.
All right. I guess one other quick question, or it doesn't even have to be a quick question. One of the things that the legislature has indicated that the courts are to do in situations such as this are to consider other options for mental health treatment, competency restoration. Is there any alternative programs, diversion programs of any kind that either party is aware of in this jurisdiction that it believes the court should consider as an alternative to inpatient competency restoration in this case?
Your Honor, I do know, for purposes of general consideration would be the forensic navigators, but I don't know that we have an opinion from the forensic navigators on whether or not he would be a candidate for their assistance. That's the only program I'm aware of, but I leave Ms. Briscoe to speak up on any others that she is.
Your Honor, I'm unaware of any other alternative program that for Mr. Parker.
Yeah, and I will tell you that that is of great frustration to the court as well. And that's certainly not either attorney's fault, it's not Mr. Parker's fault. All right. Well, the court has considered the argument of both attorneys. I think that I don't know that there's a lot of disagreement regarding the legal framework that the court is supposed to apply here. I think what the court has heard from both attorneys is this is not a criminal trespass in the first degree is not a per se serious offense under RCW 1077, one of these serious misdemeanor, gross misdemeanor offenses. It is not a per se serious offense. Any and all misdemeanor offenses that are not per se serious offenses are eligible to be considered serious offenses within the legal framework outlined by the parties in RCW 1077 665 sub 3, specifically the factors enumerated under 3B, which indicates that the court must consider whether or not one or more of the following factors creates a situation in which the offense is serious. So the court's going to go ahead and look at all four of these factors at this point. Sub 1, charge includes an allegation that the defendant inflicted bodily or emotional harm on another person, or that created a reasonable apprehension of bodily or emotional harm. That is not present here. The court has reviewed the probable cause statement that has been filed by the prosecution. Ms. Gris.
Okay, so it was present in his past crimes, but not in this one. That's why they keep ignoring it. Remember I said, remember that he had 3 battery charges or something?
I think accurately summarized what the allegation here is, and that is that Mr. Parker had been criminally trespassed from the Safeway grocery store in the city of Lakewood, and that on September 14th, 2025, he re-entered that establishment and began consuming food there at the Safeway store when employees of the store, obviously aware that Mr. Parker had been previously trespassed, I believe just the day before, and was not supposed to be there, contacted the Lakewood Police Department. Officers responded and placed Mr. Parker under arrest. And looking at the arresting officer's probable cause statement, the officer noted that it should be noted that Mr. Parker has been trespassed from several businesses in the city of Lakewood, and it appears that he shows no interest in abiding by the trespass agreements. That's relevant, I think, here for some of the reasons that Mr. Graham has articulated. The second sub-factor, sub 2, the extent of the impact of the alleged offense on the basic human need for security of the citizens within the jurisdiction. I don't see anything outlined in the probable cause statement, the factual basis for this charge, that suggests that Mr. Parker's conduct posed an impact or a risk to the basic human need for security of the citizens within the jurisdiction. I think Mr. Parker clearly suffers from mental health issues. His behavior and his presence, frankly, may be uncomfortable to some, but I do not see that as impacting basic human need for security of the citizens within the city of Lakewood. I don't see that any of Mr. Parker's actions or conduct alleged in this case had such an impact. The sub 3, the third factor the court is to consider in whether or not this is a serious offense within the context of competency restoration is the number and nature of related charges pending against the defendant. I think this factor actually does weigh in favor of finding the offense to be a serious offense. Mr. Graham has articulated a significant number of charges of this nature that have been filed against Mr. Parker in this court and other courts that have either resulted in convictions or dismissals due to a lack of competency. Essentially what the prosecution is saying is I think it was over 90 cases that have been referred for the charge of criminal trespass is further evidence of what the arresting officer says in the probable cause statement in this case, which is, again, that Mr. Parker appears to show no interest in abiding by trespass warnings from private property owners. And that the sheer number and the related nature of these charges indicate that Mr. Parker is a threat to continue to repeatedly continue to commit this offense unless there is some intervention, which here the government is asking for competency restoration in the hopes that improved mental health treatment and mental health care may break that cycle, if you will. So I do find that the number and nature of the related charges pending against Mr. Parker weigh in favor of finding this to be a serious offense. The fourth factor is the length of potential confinement if the defendant is convicted. Again, this is of concern to the court, and I understand Mr. Graham's argument. Statutorily, this is a gross misdemeanor offense punishable by up to 364 days in custody. Mr. Parker's criminal history and the number of prior referrals and charges involving criminal trespass, Mr. Graham is correct, it is unique. It is a far greater number of prior cases than this court typically sees with most defendants. That said, I cannot remember the last time, if there has ever been a time, that this court has imposed 364 days in custody for an individual found guilty of criminal trespass in the first degree. It is typically in this type of offense in this court is usually a credit for time served or no term of confinement for criminal trespass in the first and the second degree. But again, Mr. Graham is correct. Mr. Parker's criminal history is abnormal. It is not the typical number of prior criminal trespass cases that this court sees with an individual defendant. But the length of potential confinement, given how long Mr. Parker has been in custody, frankly, that factor is a wash in the court's mind. It cuts both ways as far as the court is concerned. The final factor, sub 5, the number of potential actual victims of persons impacted by the defendant's alleged acts. Every one of the previously prosecuted, whether
I am
it be
crazy.
resulting in conviction or dismissal due to competency, every one of those prior charges of criminal trespass, which is approaching 100 prior cases, involves at least some form of an alleged victim, whether it be a business, whether it be an individual property owner. Inherent to the charge of criminal trespass is the fact that the defendant is alleged to have violated the property rights of another individual or entity, and that creates a victim. And so there is a significant number of victims that have been impacted and are potentially going to continue to be impacted if Mr. Parker continues to be arrested and charged with crimes of criminal trespass. So the court finds that factor 5 weighs in favor of finding that this is a serious offense. The court under RCW 1077 665 3A, 3B, in order to find the offense qualifies as a serious offense where it otherwise would not be a serious offense, court must determine the, excuse me one second there, must find the presence of one of those or more of those five factors. The court has. The court has found that two of the five apply directly to Mr. Parker's history and the facts alleged in this case. The court is going to find that the prosecution has met its burden of establishing that this should qualify as a serious offense under RCW 1077665B, 3B. The next question is whether or not, even though it is a serious offense, does the government have a compelling interest in seeking restoration in this case? The short answer is yes, from the court's perspective. Again, these are, as they go, relatively minor offenses, criminal trespass, but the sheer aggregate number of these charges and incidents that have been alleged in Mr. Parker's history leading up to and including the present charge that is before the court today, the other case in Olympia Municipal Court that apparently was dismissed yesterday, again, another charge of criminal trespass. Mr. Graham's argument to the court is the government's compelling interest is ensuring the enforcement of the law in the jurisdiction and the corresponding community care and safety. And the court does find that the government has a compelling interest in ensuring that the law is followed and that the community is safeguarded. So I am going to find that there is a compelling governmental interest here. Finally, Ms. Grisco is right. The question is, okay, well, if there's a compelling interest, is the remedy that's being sought narrowly tailored to accomplish that compelling interest with the least amount of intrusion upon Mr. Parker's rights? Because this is involuntary commitment. Mr. Parker does not want to be sent to inpatient treatment. And that was part of the reason that the court inquired about and is required by the legislature to consider, are there any available alternatives to inpatient restoration to accomplish the compelling interest that has been established by the prosecution? That is there any other way to ensure that Mr. Parker is having his mental health issues addressed in a meaningful way, such as to restore his competency to understand the nature of the proceedings against him in this case and to assist his counsel? The court is not aware, unfortunately, of any alternative programs or diversion programs in this jurisdiction presently available to Mr. Parker to provide that level of care that would serve as an alternative to ordering a term of inpatient restoration at the Department of Social and Health Services. I wish there were. Unfortunately, I'm just not aware of one at this time. So the court at this time, for all of those reasons, I am going to grant the prosecution's motion. I am going to find that this is a serious offense, as I've indicated, excuse me, and that the government has a compelling interest in requesting restoration of competency with Mr. Parker. The court is going to order a term of inpatient restoration treatment to be conducted at a facility designated by the Department of Social and Health Services for a term not to exceed 29 days in duration. Mr. Graham, do you have a proposed order?
I do, Your Honor. I did just load one up in Oakworks. And Your Honor, I can also tell you that I did receive a service plan from the forensic navigator that did not recommend forensic navigator services at this time. I just put it in my email.
First thing the court's going to do is set a hearing date. It says I'm currently editing the document, but it won't let me edit it. We're just going to set a competency hearing for Friday, February 6th, 2026. That is 29 days from today. Or excuse me, 30 days from today. That will be on the Nisqually calendar.
Your Honor, may I add Ms. Capone's email address?
Sure, let me get through the order and then I will add that for you in just a moment.
Thank you.
I don't want millions. No. No.
Okay, and for defense counsel, Ms. Crisco, what is the email address you would like used?
It is Patty C, PATTYC, as in cat, at pacificpointlaw.com, please.
Civic Point is PACIFICPOINT,
Yes.
and then law.com.
Yes, Your Honor.
All right. And Mr. Graham, yours has a telephone number and a fax number. Is that sufficient?
Your Honor, if the court can add legal to the number 2, at cityoflakewood.us, that'll go to the criminal team.
Legal2 at cityoflakewood.us.
Yes, Your Honor.
Got it.
So, he's going to be restored to competency. Makes sense to me. I mean, that's sort of what the law is there for, right? Anyway. Let's see what we're going to do next. Let's do restitution. We're gonna do a case about restitution.
Is represented by,
There we go.
and I just had your name, Ms.
Amy
Dietrich. Ms. Dietrich is present via Zoom. We have victims, Mr. and Mrs. Bell present. Mr. Soplin is present in the courtroom with his attorney,
Squires.
Mr. Squires, and then we have Mr. Deck from probation. In preparation for today, I have reviewed the pre-sentence report. I understand that there was some character letters that I haven't seen yet. I am inclined to follow the recommendations of the pre-sentence report.
Your Honor, forgive me, I don't know what that was. The state and I didn't get our copies of the PS.
Okay, it's probation.
Just probation.
Yeah.
I did, to Miss Guadiana, I did submit the character letters, but she's not here.
Right.
I do have them in physical form, Miss Dietrich. Received hers via email. Would you like me to approve?
Yeah, I can look at them real quick. Do you have any issue with that, Ms. Dietrich?
No, that's fine, Your Honor.
Okay.
Miss Dietrich did the same ones.
Yeah, that's no problem.
They're very short.
Okay, I will look at those.
I think this is California, and I think this happened yesterday. Yeah, Waffle House sounds amazing right now. we would all have so much
Mr.
fun
Squires, these have been
if we
filed.
went to Waffle House.
Yes, they have, Your Honor.
Okay.
May I ask Your Honor to just keep those as part of the court's file, or
Okay.
is that redundant? Because I
That's
didn't
fine.
file them.
I'll hold on to these. Okay. So, Mr. Sopelin, can you please state your full name for the record?
Yes, Your Honor. Jacob
No,
David
Ben.
Sopelin,
What is your date
No.
of birth?
12/12/79.
No.
The court has previously accepted your plea of guilty. The court now accepts the terms of the plea. It is the judgment of the court that Mr. Sopelin is guilty of amended count 3, criminal possession of a forgery device, a class 6, non-dangerous, non-repetitive, undesignated felony committed on or about April 30th, 2017 in violation of ARS 13-2003, ARS 13-2001, 13-610, 13-301 through 304, and other applicable law as noted. This
Monica, no. No.
Undesignated offense.
Don't Google that. Just move on.
Pre-sentence report written by Ms. Smith from probation. I have reviewed the letters handed to me. It is my inclination to follow the recommendation of probation, which is 3 years of probation.
Don't do it. Just trust me on this one and just let it go.
So I will start with you, Ms. Diedrich. What is the state's recommendation?
Thank you, Your Honor. The state's recommendation is also for 3 years. There is a pretty large amount of restitution that's due, and I think it'll take that long, if not longer, to pay it off. I don't know if the Bells want to be heard. I believe they're appearing virtually. I did also receive a written victim impact statement from Ronald Monks, who is the representative for the business victim in the case, which is Natural Edge Custom Homes. And he just indicated about the damage to his reputation that was done due to this because of Mr. Sopelin's actions and creating a fake business email and essentially pretending to be a representative of this company. So that's my recommendation. I will defer to the Bells if they wish to be heard with regard to anything else.
Okay, Mr. and Mrs. Bell, you're currently mute. You're welcome to unmute and make statements. I do note that you were interviewed by probation. She did include your statements in the pre-sentence report, but if you have anything to add, I'd love to hear it. There you go.
Oh, thank you. Thank you. Yeah.
Go.
Unfortunately, we were
Look it
sent
up.
paperwork from the Attorney General's office saying that the sentencing meeting was going to be in Globe. So we're in Globe, and we're just really astonished that it happened like this. But in regards to any kind of statement that we wanted to make, it's just that we wanted to thank the people from the Arizona Attorney General's office. We also wanted to thank the Gila County Superior Court and you most of all for helping us with this very, very tedious and long drawn out process. We don't know what we could have done without your help, and just want to thank you. And that's all we wanted to say.
All right. Thank you so much. I'm sorry if there was a mix up. I know that happened to Mr. Sopelin last time too. So unfortunately we're a small county, but our courthouses are kind of far apart. So I hope, I'm glad you're able to appear by Zoom, and I hope when you're on your way home, you have a safe drive. Okay, Mr. Squires, do either you or your client have a statement?
Your Honor, I'll go first. Very briefly, I don't want to belabor the point. It's a probation recommendation. Jacob David Sopelin is a man with no prior criminal history. I don't want to minimize any allegations or anything of that nature in this case. Prior to becoming an attorney, I was a carpenter. I was a construction worker. They're very high intense places where crews will show up and they will demand this of you. And if you don't get that crew working right now, they'll go do another job and delay your job 3 weeks. So I could see the real, the temptation to break the law. It's never appropriate to ever break the law. And he's sitting here as a criminal defendant. So, I mean, that's a pretty significant, just thinking of it.
So it wasn't his fault, but he's taking responsibility, but it wasn't his fault.
And I was a younger man at the time, and I could see signing off, oh yeah, he says it's okay because he won't care if I sign his name, which is a crime. It is absolutely a crime, and it's why we're here. Unfortunately, they don't have a lot of ethics classes in the carpentry world. It's a lot of high stress, and he made a horrible mistake, and he'll be paying for that the rest of his life. I do believe that he had, from all my conversations with him since 2021, he did really have the expectation to build the Bells their home. It's a very significant thing to do, to enter a relationship, to build something as important as a family's home. It's a sacred trust. We apologize for our criminality on this side, really, really, to the Bells, and from the bottom of our hearts. We're sorry that they couldn't be here. My office did that to Mr. Sopelin last week. But we have every absolute expectation to pay back every dime of restitution. And we have a plan in place to do that. And it's not easy. And if it's any consolation to the Bells, Mr. Sopelin has lost everything as a result of this. His home life, his wife, access 24 hours to his children. If they wanted suffering he has. And we're not self-pathetic where we feel sorry for ourselves. We're strong, and we're going to build our way out through truthfulness, integrity, and doing the right thing and getting this behind. But we do have a plan to pay this restitution. I would ask for a smaller amount on a monthly restitution, just because he's been instructed to pay more. If it's $200 a month, pay $500. Just never pay below $200, or you run amok with the courts. So that's kind of what I always counsel my clients on. Again, it's a stipulated term. I just want the court to know, from everything I've seen with Jake, as I know him, that he really did have the utmost of intent. And Your Honor, the Bells gave him a significant amount of time, and they showed up in like August. And there wasn't nearly the progress that they had expected due to some delayed permits and things like that. And they said, we gave this young man way too much money. I don't like where the progress is. And the whole thing kind of fell apart. But I think had that not happened, this would have been a completely different situation, because I believe, at least I've been told, that Mr. Sopelin intended to build them exactly what was promised. They just fired him before he got the chance to complete the act. We're not minimizing anything we did wrong.
Not his fault. We're not minimizing it. Not his fault.
And we're now criminal defendants on this side. But it wasn't that type of crime that he woke up and said, I'm going to hurt somebody and take advantage of them. I'm going to try to be a builder, and sometimes I'm getting used to coloring outside the lines. And in this instance, that absolutely broke the law. It is never appropriate. If Your Honor is inclined to oppose it in jail, I would just ask that it be deferred so he can pay the restitution and make the Bells whole. He has every opportunity to make this right and to grow and gain from this and not let it devastate his family. And we're just thankful for that opportunity.
Mr. Sopelin, you get the final word.
Thank you, Your Honor. I just want to take a minute, and I'm a little nervous, but I just prepared a couple notes, and I wanted to express to you and to the Bells, specifically just my remorse and my sincere apology. I'm sorry for just the poor judgment that I displayed that day. As Mr. Squires stated, that wasn't my intent. I didn't set out to do that, but I understand wholeheartedly that it's been disruptive to their lives, and it was a stressful process that was compounded immensely by my actions. And so I'm very, very, very sorry, and I just want them to know that. I'm going to work diligently with this restitution. I want them to be made whole, and I won't stop until that's done. I'm committed to that, and I understand how important integrity, honesty, truthfulness, all these things are in relationships, and I violated that with them, and I'm very, very sorry. I would ask that they have an open heart and open mind working through this as they have. I would like to earn that spot, earn that trust, not in any business relationship or anything beyond that, but hopefully by the end of this, they can see the true colors of who I am as a person. And again, I'm very, very sorry, and I take full responsibility for it. Thank you, Your Honor.
Okay. So in coming to this sentence, the court has considered the following aggravating factor. This is a victim crime. The court finds that the victims have suffered financial and emotional harm. Financial harm is significant, as is the emotional harm. And I find as credible the victim's statements about the significant emotional distress they have suffered. In mitigation, I find that Mr. Sopelin is employable, that he does have community support, that he has accepted responsibility, and has expressed remorse, which the court finds credible. weighing these aggravating and mitigating factors, it is the judgment of the court that imposition of sentence is suspended and Mr. Soapland is placed on probation for a period of 36 months to date from today's date. I'm not going to impose jail at this time because the main reason I am imposing probation, this is a lot of money that we're dealing with, but I want the victims to be made whole, and for them to be able to be made whole, Mr. Soapland, you need to be out working, and I don't think putting you in the Department of Corrections is going to promote that. And I do believe your attorney that you have yourself suffered significantly from this and have learned a lesson, and this will not be something you will ever do again. It is further ordered that Mr. Soapland pay restitution in the amount of $560,000, a $20 time payment fee, and a $20 probation assessment for a total of $222,600. That restitution shall be to Mr. and Ms. Bell and or their insurance company. Towards that restitution, Mr. Soapland, that figure that your attorney suggested of $200 a month was actually what probation suggested. So beginning on January 9th, 2025, you need to pay at least $200 a month. That's not even, that amount's not going to chip away at that big amount, but I know the nature of your business that sometimes you have good months, sometimes you don't. You'll be in violation of probation if you don't pay at least $200 a month, but as your attorney said, you need to be paying more than that. Just I know the nature of your business ebbs and flows. So when you get extra, you need to put it towards restitution, because it is a term of your probation that you pay that restitution in full. You're also ordered to pay a $65 monthly probation fee beginning on January 9th of 2025. Any payments made by you will be applied to restitution first. And it says here, and I don't know, Mr. Deck, there's a suggestion that a criminal restitution order be filed at the time of sentencing. I'm not inclined to do that right now. What is your position, Mr. Squires?
I would think that normally that would be as if he went into some sort of default
Right.
to put a lien against him. So I would say it would be premature in that regard, and we do have the plan to pay the bills back and make them whole. If ever he becomes deficient on that, absolutely, I would do that. But at this time, I can't really think of why that would be appropriate.
I agree. Ms. Diedrich, do you have a position on a criminal restitution order at this time?
I agree, Your Honor. That would be appropriate at the end of probation or if there's a problem with regard to the payments being made.
Okay, so I'm not going to impose that term. There are several other terms of your probation. They're all going to be explained to you. They're all important. I'm not going to explain each one. They'll be clearly set forth in the terms, in the terms and conditions of probation. You're going to get a copy of that. You're going to sign for it today. So you need to read all of them and comply with all of them. This is a Class 6 felony. It's undesignated right now, but if you violate any of the terms of probation, you could be brought back. And if a violation is proved, your probation could be revoked and you could be sentenced to prison for up to 2 years. That's the aggravated maximum. Do you understand that?
Yes, Your Honor.
Okay. So failure to maintain contact with the probation department will result in the issuance of a criminal restitution order for unpaid fines, fees, surcharges, or assessments and unpaid restitution. That's what we were talking about before. We don't believe that's appropriate at this time because we are all confident that you're going to be making those payments, okay?
Okay.
All right. You have the right to petition this court for post-conviction relief and to have a lawyer represent you. If you cannot afford a lawyer, one will be appointed for you. If you cannot afford copies of the necessary records or transcripts, they will also be provided at no cost to you. If you want to petition for post-conviction relief, you must file a notice within 90 days from today's date or you lose the right to seek relief. You'll sign a copy for your post-conviction relief rights. There are also some other things for you to be aware of. This is a first-time felony. I think under the new law, it's treated as a misdemeanor for all purposes. And I'm not sure, do you know, Mr. Squires, if it gets rid of the right to vote, his other civil rights?
I always make them double check because I think during the pendency of probation, your first one needs to have a court order to restore it automatically under 13905 et sec.
Right.
So I always tell them to double check before they do anything with firearms, especially, and voting at a minimum.
Yep. And so because this is your first time felony, if you successfully complete probation and you're discharged for probation, usually your civil rights are automatically restored. But as your attorney said, make sure to check on that. Also, if you complete probation successfully, pay all restitution, you'll have a right to set aside this conviction after certain statutory provisions have been met. You also have a right after a certain period of time to seal your criminal record. You'll receive information on that, and you can ask your attorney about that as well. Okay? That's down the road. But for right now, you have a tall order ahead of you. But I think everyone is confident and you can do that. And again, I believe you, and you say you want to make the victims whole, and that's your number one priority. Okay?
Okay.
Anything further from the state?
No, Your Honor. Thank you very much.
Anything further from defense?
No, Your Honor. Thank you for your time.
Thank you so much. So Mr. Soapland needed to come up and give a fingerprint and sign for these rights.
Well, yeah, Gila County. That's Colorado, right? Payson courtroom. I think it's Colorado. I'm sorry, California. I don't know why I'm saying Colorado. I think that's California. So we went to Tennessee tonight. Then we went to Washington. And then we went to California. Yes, sir. That's good. That's good court right there. So what is today? Today is Tuesday. If you're here for court, all the court clips are over. So thank you so much for coming out. I really, really appreciate it. All right. Today is Tuesday already. So tomorrow we have 2 lives. One in the morning, one in the evening. It is quite possible that my live streams on Sunday might be moved to 5 o'clock instead of 8 o'clock. It just says that more of my people are on at that specific time. So I think I'm going to do that. So this Sunday might be a different day. I mean, yeah, I'm just going to leave it at that. This Sunday is going to be a different day, guys, okay? Thanks for coming out. I am going to set up OJ, Bobby. I'm crossing my fingers that we have a little bit of EDTA for you today. You never know. You just never know. We're almost at the end, so they might be fresh out of EDTA. Who knows? Maybe Furman can plant some in this court. Thanks for coming out, guys. Behave, okay? I'll see you again real soon. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't Come and see for yourself.